All right, hey everyone, welcome to the 2025 IMT December finals. Dr. Ian Lamper isn't here, but I'll be helping host as well as preside for this tournament. Now, both teams, you've done a lot to get here. You've went through semifinals, you've went through 4 rounds of extensive and I'm sure very exciting preliminary rounds, but here you are battling out for the championship title. So, we're gonna start off with some judge introductions. Can the judges turn on their cameras? Just where you're from, maybe your mock trial experience, and any words of encouragement for the competitors. We'll start by how I'm seeing everyone on screen. We'll start with Miss Ellen Song.
Hi guys, I'm Ellen. I'm a law student at UCL and I'm very happy to be here. I did mock trials throughout high school and it's really like one of the main reasons I went to law school. So I'm really happy to see people show up, especially since holidays are really near. So yeah, excited for the round.
Thank you, Ellen. Next, Miss Avishi Pandya.
Hi, everyone. My name is Avishi Pandya. I did mock trial and teen court throughout high school, and I'm currently a member of UT Austin's undergraduate mock trial team. I am so excited to see you guys do such an incredible round.
Miss Lydia Ferris.
Hi everyone. My name is Lydia. I'm a competitor for UCLA currently. I'm a fourth year. I coach. I'm a high school coach for Alabama mock trial, so I'm really excited. I know that this is a high school tournament, so really excited to see what you guys have got.
Thank you. And finally, for myself, I will be presiding, but I will also be having a ballot. In the case of a tie, I believe we're going to be determining through a point differential or PD. But a little bit about myself. I'm Joshua. I'm currently a competitor at U Chicago Mock Trial, and I've competed in IMT since its first inaugural tournament back in 2022, 2023, before going to college. And if my word is any good, I know how important IMT is to promoting high school trial advocacy. But good luck to both teams. And with that, are both teams ready to start?
Yes, Your Honor, the plaintiff is ready to begin.
Defense?
The defense is also ready to begin.
All right. Well, we'll call the case. My name is Judge Jung. Scoring judges, please look at the 2 buttons on the lower left of your screen. Remember to keep your audio off and video on until the end of trial. You should also have your video set to hide all non-video participants. Remember that all judges should be well, I guess there's no tab easy ballot, but the form that Ian did send you and scoring as you go, just remember that it is on a Google form. There is no tab easy ballot. Now, whoever's keeping time for this trial, ideally a volunteer from both teams. Can you identify yourself?
Yes, Your Honor. Good evening. I'm David Leonel, and I will be timekeeping for the plaintiff on today's case.
Perfect. Defense?
Good evening, Your Honor. My name is Mira Jang, and I'll be timekeeping for the defense today.
Good evening. With that, can we make appearances for the attorneys?
Yes, Your Honor. Good evening, Your Honor. My name is Joey Sanchez, and I'll be conducting the opening statements today. And I, alongside my co-counsel, Isabel Alfonso, will be conducting the closing argument.
Good evening, Your Honor.
We proudly represent the plaintiff in today's case, the estates of Arthur Henley. Additionally, Your Honor, we are also here with our tech for the plaintiff.
All right. Defense?
Good evening, Your Honor.
Good evening, Your Honor. My name is Tobin Hill, and today, joined by my co-counsel, Miss Anya Luo,
Good evening, Your Honor.
together we represent the defense on behalf of Dr. Elias Hornby.
Good evening, Your Honor.
Good evening. All right. Plaintiff, I think this is a civil case. Plaintiff, do you have any preliminary matters?
Your Honor, but before we begin, may our witnesses also introduce themselves, Your Honor?
Sure.
Good evening, Your Honor. My name is Jayda Lezama, and I will be playing the role of Finley Riveras.
Good evening, Your Honor. My name is Samuel Perez, and I'll be playing the role of Dr. Alex Zuzak.
Next,
Good
Your
evening
Honor,
to you.
plaintiff has a few housekeeping matters we would like to address.
Of course.
Firstly, we would like to know your preferences regarding screen sharing exhibits for the court. Would you like for us to ask permission before doing so, or should we just let the record reflect?
Please just let the record reflect. Thank you.
Yes, Your Honor. We'd also like to inform you that the bailiff for the plaintiff will be announcing the time elapsed throughout the duration of his trial via the usage of the Zoom chat.
Fantastic. The only thing I ask for both teams is the same, is when time does elapse for a center procedure, remind us in the chat, don't cut the other side off.
Yes, Your Honor. We like to ask that all admitted exhibits keep the pre-marked numbers regardless of the order in which they are introduced.
Of course.
We'd also like to know your preferences regarding redirects and recrosses. Will they be entertaining your courtroom today?
I believe for the IMT jurisdiction, they are allowed. I'm not sure if a redirect is allowed, but hopefully there's no redirects.
Yes, Your Honor. Once an objection has been sustained, should we move to strike the offending testimony, or should we just assume it's been stricken?
Please always move to strike.
Yes, Your Honor. At this time, we now invoke Rule 615, the constructive sequestrations of all witnesses barring parties and party representatives.
Of course. Do you have a party rep?
No, Your Honor.
All right. And I believe defense's party rep is Miss Elias Hornby. Is that correct?
It is, Your Honor.
Perfect. Anything else, Mr. Sanchez?
Yes, Your Honor. We would also like to remind the court today that pursuant to Rule 603, all witnesses have been pre-sworn in today's case before testifying.
So evoked.
And finally, Your Honor, we have a substantive matter to address. Your Honor, permission to screen share pretrial order 4 for the court?
Sure.
Your Honor, pursuant to pretrial order 4, which states that exhibits 8 and 9 have been pre-admitted, Exhibit 8 is a sticky note that the defendant wrote to the intern, Finley Rivera's, on the day of the incident. We bring it to the court's attention as the plaintiff plans on utilizing Exhibit 8 in today's trial.
All right, so noted.
And finally, Your Honor, we would also like to bring the court's attention to the case law in the state of Tilly, with Pavilion versus Carlson, that in medical malpractice cases, the trier of fact must consider only the information the defendant obtained or should have reasonably obtained throughout the course of medical care to determine whether or not the defendant followed proper medical protocol.
Any objections, or is that your understanding as well, rather, Mr. Hill?
It is, Your Honor.
All right, let me just look at this real quick. It's the Pavilion v. Carson, you said?
Yes, Your Honor.
All right.
And with that, Your Honor, the plaintiff stands ready for opening statements.
All right. Defense, anything?
No, I think the plaintiff covered it all. We're ready to move on.
Perfect. In that case, we'll now hear opening statements from each party. Everyone should make sure they're in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. With that, plaintiff, whenever you're ready.
Yes, Your Honor. Joey Sanchez for the plaintiff. May I proceed?
Whenever you're ready.
May it please the court, Your Honor, opposing counsel, members of the jury. She took a grave risk without a good reason. Now imagine for a moment that you entrust your car to a mechanic, one that you've known and trusted for years. You tell them to check everything. Brakes, fuels, tires. You tell them to make sure it's safe. Sounds simple enough, right? But then you start seeing that the mechanic hands a job to an inexperienced assistant. That they don't check the car themselves and they send you off on the road. Ladies and gentlemen, that's not just carelessness, it's a failure. It's a failure that could cost you your life. Members of the jury, that is exactly what happens to Arthur Henley. Only this time, instead of trusting a mechanic, he trusted a doctor. Instead of an inexperienced assistant, there was a messy intern. And most importantly, instead of a car, it was a life. A life that was lost. And you'll hear today that this tragedy occurred because Dr. Hornby took a grave risk and without a good reason. Now we, the plaintiff, we have the job to prove to you today, by a preponderance of the evidence, that it was more likely than not that Dr. Hornby committed medical malpractice and wrongful death. For medical malpractice, we have to show you that 1. Dr. Hornby owed Arthur Henley a duty to meet the applicable standard of medical care. And you're going to hear from expert toxicologist Dr. Alex Zuzan, who will explain that Dr. Hornby and Dr. Hornby alone had the responsibility to ensure care for Arthur Henley, including every single intern she was supervising that day. 2, we also have to show you that Dr. Hornby, he breached that standard of care. And you're going to hear from the intern, Finley Rivera's, that she was rushed and told to do unnecessary tasks by Dr. Hornby. In fact, you're going to hear from the defendant herself, Dr. Hornby, telling you that she knew Rivera's was a mess, yet still chose her to prepare the syringe. And 3, that this breach was the proximate cause of the harm done to Arthur Henley. And by proving medical malpractice, we inherently prove wrongful death, as that was the wrongful act that led to the tragic death of Arthur Henley. All because she took a grave risk without a good reason. Ladies and gentlemen of the jury, you will hear today that Arthur Henley did not walk into that hospital asking for some extraordinary treatment, but he just asked for routine care. He trusted his doctor, but unfortunately, that trust cost him his life. All because of a doctor who took a grave risk without a good reason. Members of the jury, when you weigh the facts and evidence of today's trial, you will reach the only verdict supported by the evidence and demanded by the law. And that is to find Dr. Hornby liable. Thank you.
Thank you, counsel. Defense?
Yes, Your Honor. May I proceed?
Whenever you're ready.
May it please the court. The hospital mishandled the medicine. It's February 16th, 2025. Langford Hospital is overflowing. Patients packed into hallways, nurses pulled into double shifts, doctors sprinting from crisis to crisis. It is a system stretched thin. And right in the middle of it all is an overworked, undertrained intern named Finley Riveras. An intern who had already made mistakes. An intern the hospital knew was struggling, but an intern they kept anyway. That day, the intern is told to prepare an injection. Don't mess this up. But she does. She hands our client, Dr. Elias Hornby, a syringe she never should have prepared. Dr. Hornby administers it to a patient, Arthur Henley, and minutes later, Mr. Henley collapses. Minutes later, he dies. The plaintiff wants you to believe that my client took a grave risk without good reason. But you will learn that Dr. Hornby didn't take that risk because she wanted to, but because the hospital forced her to. The plaintiff took on a burden today. They must prove, more likely than not, that it was Dr. Hornby's decisions that caused Mr. Henley's death. We, the defense, we don't carry that burden. We don't have to call a single witness or show you a single piece of evidence. But we will, because the evidence reveals 3 facts the plaintiff cannot answer: the mislabeling, the mistake, and the mishandling. First, the mislabeling. You will learn that the medicine injected into Mr. Henley was labeled as a harmless sedative when it actually contained a dangerous drug. And the 2 drugs, nearly identical in appearance. The hospital mislabeled the drug. The hospital mishandled the medicine. Second, the mistake. You will hear that the person who prepared Mr. Henley's syringe was not Dr. Hornby. It was an intern. And you will hear how this intern was not competent, how she had made mistakes before, even mixed up syringes. It was the hospital who mishandled the medicine. You will hear from the hospital's administrative coordinator, 12 years at Langford, nurse, supervisor, administrator, someone who knows how this hospital really works. She will tell you the hospital was understaffed, the equipment was outdated, the intern to supervisor ratio was dangerous, and that Mr. Veras had been making mistakes long before Mr. Henley's death. The hospital mishandled the medicine. Third, the mishandling. You will hear how attempts were made to remove the intern from clinical duties. Dr. Hornby, my client, will tell you how she asked the hospital to fire the intern and how the hospital refused. The hospital mishandled the medicine. This case isn't about arrogance or recklessness. It's about a system held together with duct tape finally breaking. As the hospital's administrative coordinator will tell you, hospitals are chain reaction environments. One weak link and everything falls. That weak link wasn't my client. It was the hospital. The hospital who took a grave risk. The hospital who mislabeled the medicine. The hospital's intern who made the mistake. And the hospital who mishandled the medicine. And when all the evidence has been presented, my co-counsel, Ms. Anya Luo, will stand before you and ask for the only verdict the facts support. Find Elias Hornby not liable.
Thank you, Mr. Hill. All right. I'm going to give scoring judges just a minute to finish up some comments and scoring. Give me a thumbs up on the Zoom chat once you're ready. Perfect. Thank you, Lydia. Thank you, Ellen. Perfect. We have everyone. All right. Plaintiff, are you ready to call your first witness?
Yes, Your Honor. The plaintiff now calls Finley Rivera to the stand.
All right. Mr. Perez, you're pre-sworn, and you may proceed whenever you're ready.
Good evening. Please introduce yourself to the court.
Of course. Good evening. My name is Finley Riveras. I'm 24 years old and a student at the Tilly School of Medicine. I went to University of Chicago and got a degree in biology back in 2023.
Mr. Veras, did you participate in any medical internships while in Tilly?
Well, yes, I did. I interned at Langford Hospital for a while, assisting several physicians.
Out of the physicians you previously mentioned, with whom would you work with the most?
I was most consistent with Dr. Hornsby.
And what were your responsibilities working under Dr. Hornby?
Most of my responsibilities were to follow my supervising physician's instructions, whether it be things like preparing medication, cleaning up work areas, simple tasks like that, because I'm not licensed yet. I'm just learning. And honestly, it's a great opportunity to learn about what I love.
And how would you describe your experience working with Dr. Hornby?
Well, honestly, it was a good experience in general. I mean, during my internship with her, I found out that Dr. Hornsby's medical expertise is so inspiring. But to be quite honest, she was a bit intimidating at times and wasn't always supervising my work.
Could you give an example of what you mean by that?
Yes, I can. Actually, this was right before Mr. Henley came in for his treatment. I was cleaning the room since they had just treated a gunshot victim, and Dr. Hornby was loosely supervising me at this time.
Well, I'd like to talk to you a bit more about why you're here today, Miss. Do you know why you're here today?
Yes, I do. Dr. Hornby is being sued because of apologize, Arthur Henley's passing. I'm here to testify.
Are you being compelled or forced to testify today?
No, not at all, ma'am. I voluntarily chose to be here in court today.
So, why are you testifying today?
Well, I know that there have been some accusations regarding me and my involvement with the Arthur Henley incident, and I just wanted to set the record straight.
All right, Miss. I'd like to discuss the events of February 16th, 2025. What happened that day?
Well, Mr. Henley came in for his treatment, but he unfortunately passed away after being administered his medication. He was under Dr. Hornsby's care, and I was the intern working under Hornby for that day.
Miss, I'd like to talk to you about some of the things that Dr. Hornby did that day. What did Dr. Hornby tell you to do regarding Arthur's care?
Dr. Hornby told me to go get lorazepam since it worked before, and she emphasized to be quick about it. But before I went to the other room, she slipped me a note.
Would you recognize that note if I were to show it to you?
Of course.
Let the record reflect that my tech, Ms. Gutierrez, will be screen sharing what has been pre-admitted into evidence as Exhibit 8.
So noted.
Can you see my screen?
Yes.
Mr. Veras, what am I showing you?
Well, this is the note that Dr. Hornby gave me when she instructed me to go get the medication for Arthur.
Did Dr. Hornby give you any other written instructions on how to prepare the medication?
Well, no, this was it. Most of the instructions were verbal.
How did you react to receiving a written note when most of the instructions were verbal?
Um, to be honest, I thought it was kind of odd. I mean, it's not like she had written detailed steps on what I had to do. It was just a note telling me to get the medication prepared, and she had already instructed me to do that anyways.
Thank you, Ms. Gutierrez.
Objection, Your Honor. Far more prejudicial than probative. May I explain?
Yes, please.
We believe that the plaintiff is using this to prove that there was something odd or different, and in this case, negative about giving this note. But they haven't actually explained why that is, other than instructions were given in a different form. We believe that due to the extreme lack of probative value that this witness is adding, that it was odd, and all these other adjectives that they're using to describe Dr. Hornby's actions, that it prejudices the jury against them.
Response.
Yes, Your Honor. Pursuant to Rule 403, evidence must be substantially outweighed by its prejudicial value to be inadmissible. But Your Honor, the witness is testifying to her reaction to this note based on the instructions Dr. Hornby had just given her verbally. And the witness had just testified to the fact that in this note, there were no detailed instructions and that it was simply a note saying to get the meds prepared. And the witness is testifying to her reaction to this. There's nothing prejudicial about that, as she was the one working under Dr. Hornby the day of the accident.
Final response, Your Honor?
Yes.
We have no problem with this note being added, and we have no problem with this witness saying that they received this note. But the problem that we have is this witness saying it was odd and that it was out of the norm. This does not add any probative effect. There was no probative difference between giving verbal instructions and written instructions versus giving exclusively verbal instructions. And we believe that adding all these negative adjectives to this prejudices the jury against my client.
All right, so I'm going to overrule the objection. I don't think the bar of substantially more misleading is met. However, I'm going to split the baby a little bit. I'm going to ask P to maybe lay a little bit more foundation as to why it's odd. I do feel like a little bit of foundation is lacking on that ground. But that being said, you can proceed. I'm going to overrule the objection.
Mr. Veras, were you able to finish your response?
No, I wasn't, counsel. Could you please repeat your question?
Of course. How did you react to receiving a written note when most of the instructions were verbal?
Well, I mean, I did find it a bit strange. I mean, it's not like Dr. Hornby wrote any detailed steps on the note. It was just a note telling me to get the medication prepared, in which she had already told me in verbally.
Thank you, Ms. Gutierrez. The exhibit is no longer required. Mr. Veras, could you relate to the members of the jury the verbal instructions Dr. Hornby gave you on preparing the medication?
Of course. Dr. Hornsby asked me to prepare a syringe of lorazepam, to be quick, and that I would see a clean syringe right when I walked in.
And what did you do when given those instructions?
Well, I walked into the room, I grabbed the first syringe I saw lying on the counter, and honestly, I'm not gonna lie. The syringe looked a little bit cloudy, but I figured it was fresh out of the washer and that it was just some condensation lingering.
Well, why would you grab a syringe with condensation from the counter?
Well, Dr. Hornby told me I'd find a clean syringe right when I walked in, and she emphasized being quick about it, so I trusted her instructions.
And could you walk the members of the jury through the steps you took in preparing that medication once you grabbed the syringe?
Absolutely. Once I got the syringe, I walked over to the drug cabinet that was labeled KLM. It's for drugs starting with the letters K, L, or M. So I knew lorazepam would be in there. I grabbed the bottle labeled lorazepam, but I'm gonna be honest, since we were under tight time constraints, I had to be quick. I didn't really smell or check the medication too carefully, so I trusted the label, filled the syringe, logged it at about 2:47 p.m. into the system, and gave it to Dr. Hornsby as per instructed.
Now, Mr. Veras, I'd like to talk to you about what Dr. Hornby didn't do. Did Dr. Hornby have any part in the preparation of the medication?
No, not at all, ma'am. I prepared the syringe myself.
Did Dr. Hornby supervise you at all during the preparation of the syringe?
No, she did not.
And did you follow the instructions Dr. Hornby gave you?
Absolutely, I did. I grabbed the syringe Dr. Hornby instructed me to get, filled it with a bottle labeled lorazepam, and made sure to be quick about it.
Mr. Rivera's, what role do you have in administering treatment?
Well, to be honest, I'm not a doctor. I'm just an intern. All I did was what I was told to do, which was fill the syringe. I'm not in charge of making sure the labels are accurate.
Were you responsible for making sure the proper treatment is administered?
No, my supervising physician, Dr. Hornby, was. Again, I'm just her intern.
Thank you. No further questions at this time, Your Honor.
All right, cross-examination.
Yes, Your Honor. I want to start by talking about your medical knowledge. You haven't graduated medical school yet, right?
No, not yet. As I previously mentioned, I am a medical student at the School of Tilly.
And you previously worked at Langford Hospital.
Yes, that is correct. I previously had an internship at the Langford Hospital.
And you were actually fired from that position, right?
Yes, that is correct. I was unfortunately terminated from my position.
You were terminated after your involvement with Mr. Henley's death, right?
That is correct. I wasn't terminated. I was terminated after the incident with Mr. Henley.
I want to talk about how you were feeling the day of Mr. Henley's death. On the day Mr. Henley died, you weren't feeling too good, were you?
That's correct. I did go out the night before, and I wasn't feeling really well in the morning.
You were hungover.
Yes, that is correct. I was hungover.
You were so hungover that you weren't sure why Mr. Henley was being treated.
Well, that's not true. That's not entirely true. You could say that I wasn't really paying attention, but quite honestly, us interns were not really explained everything well enough. So, yes, I wasn't paying too much attention, but either way, I was just following my instructions.
Is that a yes to my question, that you were so hungover that you weren't sure why Mr. Henley was being treated?
Well, yes, that is a yes. I wasn't necessarily paying too much attention that day.
And yet you still decided to go to work.
Well, yes, I did. I mean, I have a responsibility.
You still decided to help treat patients.
Well, I mean, yes. I mean, I have a responsibility, and Dr. Hornsby put me to work, so I did.
You still decided to handle potentially dangerous medication.
Well, if I'm entrusted to do so by my physician, I'm going to do so because that is my job as an intern.
You decided to do all of these things despite the fact that you aren't sure of a key detail of that day.
Well, yes, I mean, my physician entrusted me to do a job, and I did exactly what she had asked me to do.
Right? She trusted you, but you never told Dr. Hornby that you were hungover, did you?
Quite honestly, I don't remember. I mean, a lot had happened that day. I mean, for crying out loud, somebody passed away that day. So I don't remember gossiping with Dr. Hornsby, quite honestly.
I'm not asking if you were gossiping. I'm asking if you remember telling your uh, supervising physician that you were so hungover that you cannot remember why you are treating patients.
Objection, Your Honor.
Yes.
As to asked and answered, my witness already answered the question and simply gave clarification to her response.
It's cross. I'm gonna give it a little bit of leeway, but Mr. Hill, I think this should be probably your last question on the vis-a-vis the hangover. But I'm gonna overrule for now. Please, Miss Alfonso, feel free to re-raise.
I'll ask one more time. You never told Dr. Hornby, your supervising physician, that you were so hungover that you were not able to pay attention and remember why you were treating patients.
Again, I really don't remember. A lot was happening that day, and that hospital, quite honestly, is always jam-packed. Honestly, we work so much, we all might as well just live at the hospital.
Finally, I want to talk about the syringe that you filled. You filled the syringe that was injected into Arthur Henley, right?
Yes, that is correct, as per Dr. Hornsby had instructed me to do.
And when you went into the room, you grabbed the first syringe that you saw on the counter.
Yes, as per Dr. Hornsby's instructions.
And the syringe, it looked a little cloudy.
Yes, it was, but as I mentioned on my direct examination, I just assumed that it was condensation.
Right? You assumed that it was condensation. You had an orientation when you became an intern, right?
Yes, of course, as all interns do.
And that orientation drills into you that if there was any chance a syringe isn't clean, to not use it. Isn't that right?
That is correct. We are taught that at orientation, but again, I was just following my instructions. Dr. Hornby specifically told me to use the one that I saw right on the counter right when I walked in. So that is exactly what I did.
Dr. Hornby didn't tell you to disregard what the hospital told you to do, did he?
Objection, Your Honor.
Yes.
As to counsel testifying, these facts are in evidence, Your Honor.
Which facts are you talking about, Miss Alfonso?
As to disregarding what the hospital told her, there has been no discussion of that, Your Honor.
Response, Your Honor?
Yes, can you repeat the question and then respond?
Dr. Hornby didn't tell you to disregard what the hospital told you. May
All right.
I respond?
Yes.
This witness just testified that the reason that she did not follow what the orientation told her to do was because of what Dr. Hornby said to her. I agree that Dr. Hornby never said to disregard instructions. I agree that that's not on the record, but this witness just put on the record that she disregarded her instructions because of something Dr. Hornby said. So I'm trying to clarify that that isn't actually true.
Response, Your Honor?
No need. This is a negative inference question. I do agree there is nothing, this is not a fact, but rather I think this, Mr. Hill is asking this witness, to make sure this thing did not actually happen, so I'm going to overrule. You may proceed.
So I'll ask again, Ms. Riveras. Dr. Hornby didn't tell you to disregard what the orientation told you to do. Isn't that right?
Well, yeah, that's true. He never told me to disregard what I learned in orientation, but I had assumed that he was familiar with that syringe and that he knew where it had been. So I followed his instructions and trusted her intuition.
Thank you. Your Honor, no further questions.
All right. Any redirect?
Yes, Your Honor, briefly.
All right.
Mr. Veras, could you clarify for the members of the jury what effect your personal life has on your work?
Honestly, none. I like to keep my personal life and my work life completely separate.
And Mr. Veras, regarding the syringe, whose instructions did you follow in preparing that syringe?
Well, my physician of that day, of course, Dr. Hornsby.
And what did you fill that syringe with?
I am 100% sure that I filled that syringe with a bottle labeled lorazepam.
Thank you. No further questions at this time, Your Honor.
All right. Any recross based on the redirect?
No need, Your Honor.
All right. Well, give us a second for comments, and scoring. And again, just let me know once you guys are ready.
Your Honor, may the witness be excused?
Yes, that's it. Perfect. Thank you. Yay. Sounds good. I'm gonna need just 1 second, but all right. Plaintiff, whenever you're ready, call your second witness.
Yes, Your Honor. The plaintiff would like to call Dr. Alex Zuzak to the stand. Joey Sanchez for the plaintiff, Your Honor. May I inquire?
Go for it.
Good evening. Please say your name for the record.
Good evening. My name is Alex Zuzak, but you could just call me Dr. Zuzak.
And what do you currently do for a living, Dr. Zuzak?
Well, currently I serve as the Director of Clinical and Forensic Pharmacology at the Langford Hospital of Tilly.
And how long have you been in this field for?
I've spent the last 15 years analyzing overdose deaths, drug mislabeling incidents, and failures in hospital drug protocols.
Now, could you talk to us about your educational background, Dr. Zuzak?
Of course, after I finished high school, I obtained my bachelor's degree in chemistry from Tilly State University. Later, I earned both my master's degree and doctorate from Willow School in the field of forensic toxicology.
Now, aside from degrees, do you have any other experiences in this field?
Yes, I also spent a few years working on a postdoctoral fellowship at the Little Hamlet Drug Evaluation School, where I specialize in drug delivery systems in hospital settings.
And have you ever testified as an expert witness before?
Yes, I've testified in both civil and criminal courts on cases as an expert in drug analysis.
And does your work require any sort of methodology?
Of course, I use a method called IL. It mixes standard methods with my own personal touch and stands for investigate, learn, and link.
Well, we'll continue talking about ill in just a second, but first, is this method reliable?
Yes, it's reliable and widely accepted within my field.
And did you apply these methods reliably in today's case?
Yes, I did.
And did you have access to sufficient facts and data?
Yes, and in this case, I reviewed the statements of the defendant and other witnesses, and I'm familiar with several exhibits, including 2, 3, and 4.
Your Honor, at this time, the plaintiff would like to tender this witness as an expert in the fields of forensic toxicology and drug delivery systems in hospital settings.
Sure. I'm actually not sure if we do tender experts into their expertise. If both sides, if anyone wants to tell me if that's something we do in this jurisdiction, maybe a defense attorney could do that. If it is something in this jurisdiction, any objections?
Your Honor, we don't believe they are required to tender them as an expert. As long as 702 foundation has been laid, it is all right. However, Your Honor, we do believe if they go further into drug delivery systems, there may be certain issues that the defense might want to object to, but it depends on the context they're being used in. So as of right now, we are okay of them tendering as an expert, but we'd still like to object under the grounds of 702.
Okay, cool. Well, you certainly have that right. I'm gonna give you. I do understand it. I don't think that's something in this jurisdiction. I'm actually gonna give you. Well, in this case, the expert gonna be a wider premise of expertise in that we'll assume that 702 as of right now has been met, but rather, there's no specific area. We're not gonna be arguing on, okay, this expert was tendered of this and not that. I do believe the jurisdiction doesn't really have a rule for that. So let's just proceed as if assumed. The fields of expertise is just it's I don't know if that makes any sense, but
It does, John.
Yes, Your Honor.
Now, Dr. Zuzek, do you know why you're here today?
Yes, on February 17th, 2025, I was contacted by legal counsel representing the estate of Arthur Henley. They retained me to review what appeared to be a fatal sedative error during Mr. Henley's hospitalization at the Langford Hospital of Tilly.
Now, Dr. Zuzek, I'd like to talk a little bit more about your methods. Because earlier, you mentioned a three-step methodology, ill. Can you explain your first step for the court?
Of course, the first step was I, which stands for investigate. And as part of that step, I looked over the statements of the defendant and other witnesses to understand what actually happened in today's case.
And what did you gain from doing this?
Well, I learned that Arthur Henley was admitted to Langford at 2:34 p.m. on February 16th for acute anxiety, arrhythmia, and high blood pressure. Dr. Elias Hornby administered Mr. Henley with what she believed was lorazepam at 2:49 p.m. And upon walking out of the hospital, Mr. Henley collapsed and was declared dead at 3:17 p.m.
And what did you suspect from all this information?
I suspected that what Mr. Henley was given was not in fact lorazepam. So I requested access to the used syringe to look at it and test the chemical makeup, which moved me on to my next step, learn.
Now, Dr. Zuzek, before we get into your next step, can you briefly explain for the court what lorazepam is?
Of course, lorazepam is a common drug used to reduce anxiety, and I'm aware that it has been used to treat Mr. Henley successfully in the past.
Thank you, Dr. Zuzek. Now I want to talk a bit more about your next step, learn. Can you tell us a bit more about that?
Of course, well, after receiving access to the syringe used on Mr. Henley, I learned that the outside label matched what Dr. Hornby wrote in her report. But at the end of the day, all medical professionals should know that it is extremely important to check the contents of the drug, not just the label, before injecting patients.
Objection, Your Honor. At this time, under Rule 702B, if I may be heard.
yes.
Your Honor, we agree that Dr. Zuzak is very qualified under Rule 702A to be an expert witness, but we have problems with the sufficient facts and data he needed to form the conclusion that doctors have to double check. Because as of right now, there is no evidence on the record Dr. Zuzak has any knowledge of the specific medical procedures at Langford Hospital. He's not a physician at the hospital. He didn't interview physicians. He didn't read over their policies with interns. It's improper for him to include Dr. Hornby violated procedures he doesn't know exist.
Your Honor, if I may.
Yes, and can you remind me, Mr. Sanchez, of what facts and data we've laid onto the record right now? We don't have the courtesy of a court reporter.
Yes, Your Honor, we laid that the witness reviewed the statements of the defendant, Dr. Hornby, and other witnesses as well, and that they're familiar with several exhibits, including 2, 3, and 4. But if I may proffer, Your Honor,
Go for it.
the witness is currently working as the Director of Clinical and Forensic Pharmacology at the Langford Hospital of Tilly. The witness is seeing all these processes. And additionally, if opposing counsel wants to talk about the underlying sufficient facts and data, they can bring that up on cross-examination pursuant to Rule 705. Therefore, the objection should be overruled.
Response to that, Your Honor.
Yep.
Director of Clinical and Forensic Pharmacology means, sure, they are an expert in drugs, but that doesn't mean Dr. Zuzak is an expert in administering them, and how physicians should properly administer and how physicians should double check they administer the right drug. That foundation needs to be laid before Dr. Zuzak can make any further conclusions about it, because it really is not his area of expertise. We are missing 702B foundation.
Your Honor, if I may.
Yes.
I believe opposing counsel is objecting to the wrong prong as well, as 702B has to do with sufficient facts or data. I believe what opposing counsel is trying to object to is 702A, whether they have the educational background in order to testify as an expert witness. And the witness did spend a few years working on a postdoctoral fellowship at the Little Hamlet Drug Evaluation School, where they specialize in drug delivery systems in hospital settings. Therefore, I believe the witness clarifies the first prong of 702 and should be allowed to give this testimony.
Final word? Yes.
Yeah. Just to clear things up, our objection is to 702B because our issue is that Dr. Zuzak has not been laid on the foundation yet that Dr. Zuzak had the sufficient knowledge to form the conclusion that the physician broke certain protocols. Because there's been no foundation, Dr. Zuzak knows those protocols. Sure, he is an expert in the study of drugs, not necessarily administering them. Those are two completely different fields. And since we don't know he has the knowledge of that, he can't be making those conclusions.
Your Honor, if I may.
Briefly.
Pursuant to Rule 705, if opposing counsel wants to talk about the underlying facts and data that the witness may have reviewed, they can bring that up on cross-examination. But on direct examination, we don't have to go in depth on every single thing they reviewed in order to form their expert conclusion. Therefore, this testimony should be allowed.
All right, so it's okay. I think this does go to, it's very, very well taken, Miss Law. I do think this goes to weight and not admissibility. I do think there's a very fine line here between, I think, administering and the subtle nuances in that, but I do invite you to bring that up on cross-examination. For now, we're gonna let the expert do the conclusion, but if, Miss Law, you think something goes, again, egregiously, maybe out of this third gray area, please re-raise.
Yes, Your Honor.
Well, I'm going to repeat the question. I want to talk a little bit more about your learn step. Can you explain that for the court?
Of course, after receiving access to the syringe used on Mr. Henley, I learned that the outside label matched what Dr. Hornby wrote in her report. But at the end of the day, all medical professionals should know that it is extremely important to check the contents of the drug, not just the label before injecting patients.
And what did you do next?
Well, following this observation, I conducted a test from the remaining residue in the barrel of the syringe using a method called high-performance liquid chromatography, HPLC, which involves using an ultraviolet detector in this case specifically.
And can you tell us a bit more about this test?
Now, of course, to run the test, I mixed the drug residue from the syringe with the solvent and injected it into an HPLC machine. Then that machine uses high pressure to separate compounds based on how quickly they move through a column. And detectors then identify their chemical properties.
And what did you learn from this test?
Well, I learned that there were no traces of lorazepam, the chemical thought to be in the syringe used on Mr. Henley. However, I did discover that the chemical in the syringe was almost entirely ketamine.
Your Honor, permission to screen share demonstrative that the witness has prepared for the court today?
Go for it. This has been shown to opposing counsel, right?
Yes, Your Honor.
Fantastic.
First off, what is ketamine, Dr. Zuzak?
Well, ketamine is a type of anesthetic that can create a state of sedation or pain relief, and is approved for medical practice in the correct dosages, of course.
And what are some noticeable differences between ketamine and
Your
lorazepam?
Honor.
Yep.
403 to the previous slide, if we could go back and if I could elaborate further.
Yep.
Your Honor, we do understand that 403 has a high bar. However, we believe this bar has been completely surpassed by what opposing counsel is trying to demonstrate on screen. As you can see, there is a lorazepam syringe and there's a ketamine syringe. Now, the lorazepam syringe, it seems like there's a gray liquid inside, and the ketamine seems to have a yellow one. Your Honor, it is the defense's understanding that lorazepam and ketamine are both colorless substances that look identical. And the defense putting up this depiction, this demonstrative, making them look like two completely different substances to the eye is misleading the members of the jury, trying to prove Dr. Hornby is more liable. That's not allowed under Rule 403.
Your Honor,
Okay,
if
let's
I
make
may.
yes, let's make this clear though before you you do respond. Do you agree that lorazepam and ketamine are two liquids that are unidentifiable, have unidentifiable differences to the eye?
According to the color, Your Honor?
Yes, or anything really, to the naked eye.
Well, we're going to show with this demonstrative that there's differences in smell between the two chemicals. But regarding the colors, although they are both colorless liquids, it is proven that ketamine is slightly more yellow than lorazepam. Therefore, is why we are showing a little bit of gray as it is colorless and just a slight bit more yellow on the right. It's just there to show the differences between ketamine and lorazepam, but the witness has not stated there's a difference in colors between the two syringes. Therefore, it does not fall under Rule 403.
Response.
Your Honor, this demonstrative is heavily implying that lorazepam and ketamine look very different. It has lorazepam with this light shade of gray, the proper color, right? Clear color substance, and it has ketamine look yellow. When in reality, in Dr. Zuzak's report, it does write that they are both clear colorless substances, and if you just look at them with the naked eye, you can almost tell no difference. Now, if opposing counsel wants to make the contention that ketamine does look more yellow, then we're going to impeach on cross-examination. But if not, if they do contend that they are colorless, then this is 403. It is completely misleading the jury.
Your Honor, if I may?
Yes, again, I'm trying to get clarification here because it's been a very, very long time since I've read this case. Do you contend that ketamine is more yellow than lorazepam?
Although they are both colorless liquids, it does not specify if it is a little bit more yellow in the affidavit of Dr. Zuzak, but he does provide that there are other differences that he does not state in his affidavit. And as I just said, not only is this an untimely objection, as the witness already responded to the question, and we already moved on to the next slide, the witness has never said that there's a difference in colors between the two syringes. As I said, it's just there for the jury to differentiate the two syringes, but we never testified that they are two different colors.
I'm just gonna make sure I got you right there. I'm sorry if I sound like I'm crossing you. Yes or no? Are you contending there is a color difference?
No, Your Honor.
Okay. In that case, what we're gonna do is to remedy this. I do think this does mislead the jury to think there could be. So what we're gonna do is, if you're not contending that, we're gonna keep everything in this demonstrative the same. We're gonna change that yellow to the same shade of gray as the lorazepam. If you're not contending that, is that okay? You're free to explore, smell differences, other differences, but we're gonna constructively change this demonstrative to be published to members of the jury as shown as similar colorless liquids. Is that okay with you, Mr. Sanchez?
Yes, Your Honor. May I proceed?
Yes. And Ms. Law, is that amenable to you as well? Is that a good remedy?
Yes, Your Honor.
All right, perfect. Please continue, Mr. Sanchez.
Now, what are some noticeable differences between ketamine and lorazepam?
Well, ketamine often has a slightly sharper, more chemical odor, whereas lorazepam is typically odorless or has only a very faint smell. While odor alone is not a definitive identification method, it is a noticeable sensory difference that can be detected at the time of preparation.
Now, Dr. Zuzak, who has the responsibility to double check the syringe?
Well, the responsibility to double check rests entirely with the physician administering the injection. In this case, Dr. Hornby was the only practitioner involved in injecting Mr. Henley, and it would be inappropriate for a physician to rely on an intern to prepare a syringe without personally verifying its contents. Ultimately, the physician who administers the drug is responsible for confirming what is in the syringe before it is injected.
Objection, Your Honor. At this time, we re-raise 702B, specifically to the part about the intern.
Explain briefly.
Yes, Your Honor. Well, before you ruled about drugs and drug policies, how that's very similar, the thing about an intern, that is very separate from drug protocols. That is something that goes into administering treatment. That is fully the physician's responsibility, not something Dr. Zuzak has expertise about.
Your Honor, if I may?
Yes.
Again, 702B has to do with sufficient facts and data. And Your Honor, the witness reviewed the intern's affidavit. And again, I believe opposing counsel, as they're talking about the educational background of the witness, whether or not they have the specialized knowledge to talk about interns, again, that's 702A. And as I mentioned previously, Your Honor, the witness already studied drug delivery systems in hospital settings at a post-fellowship at the Little Hamlet Doctorates. Therefore, I believe that the witness is qualified to talk about this.
I want to once again, Miss Law, I'm gonna leave the juries as the fact finders for this one on how much they believe this expert can come to that conclusion. I'm gonna ask you to bring that up on cross. I do feel like since this witness has read all the I believe all the affidavits, or at least the interns in this case, she's able to come to some of these conclusions. If you want to talk about how valid these conclusions are, please by all means do it on cross. But I'm gonna overrule for now.
Yes, Your Honor.
Now, Dr. Zuzak, were you able to finish your response?
Yes, I was.
Your Honor, let the record reflect the tech for the plaintiff will now be ending the screen share. Now, Dr. Zuzak, I'd like to talk about your last step, link. What exactly does this entail?
Well, I linked my findings to the toxicology findings from Mr. Henley's autopsy report.
And would you recognize that autopsy report if I were shown to you?
Yes, I would.
Your Honor, let the record reflect that the tag for the plaintiff will now be screen sharing what has been pre-marked as Exhibit 2. Dr. Zuzak, do you recognize this?
Yes, it's the autopsy report regarding Mr. Henley's death.
Is it a fair and accurate copy?
Yes.
Has it been changed or altered in any way?
Not to my knowledge.
Now, who created this autopsy report?
Dr. Avialu, a doctor of medicine who works for the coroner's office of the county of Willow.
And was this made near the time of the incident?
Yes, it was made the day after on February 17th, 2025.
And are you familiar with this coroner's office?
Yes.
How?
Well, it's a government entity, and I reviewed the autopsy report they produced regarding Arthur Henley's death.
And does this coroner's office have the legal duty to create this report?
Yes, and I frequently encounter instances like these in my area of expertise.
Your Honor, barring any objections from the defense, the plaintiff now moves into evidence which wasn't pre-marked as Exhibit 2.
Any objections to this report by Dr. Avialo, Miss Agnello?
No objections, Your Honor.
All right, so entered.
Yes, Your Honor. Dr. Zuzak, what did you notice about this autopsy report?
Well, it showed that the ketamine level in Mr. Henley's bloodstream was around 10 to 12 times the typical sedation dose and within range to induce coma or death. No lorazepam, ethanol, or other noteworthy substances were found.
And how exactly does this link to your findings?
Well, as it says in the autopsy report, no traces of lorazepam, ethanol, or any other noteworthy substances aside from ketamine were found in Mr. Henley's bloodstream. This links back to my learning step as I also found ketamine to be in the syringe. However, this report confirmed that Arthur was injected with 10 to 12 times the typical sedation dose.
Your Honor, let the record reflect that the tech for the plaintiff will now be ending the screen share. Now, Dr. Zuzak, have you reached a conclusion based on a high degree of scientific certainty?
Of course.
And could you please relay that conclusion for the court?
Well, I concluded to a reasonable degree of scientific certainty that Arthur Henley was injected with not only the wrong substance, but also the wrong dosage during his hospital stay by Dr. Elias Hornby, as he was injected with ketamine instead of lorazepam, and 10 to 12 times the standard dosage of ketamine as well.
Thank you, Dr. Zuzak. That's all, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. Good evening, Dr. Zuzak.
Good evening.
Before we go any further, I just want to clear something up. Your attorney, Mr. Sanchez, seemed to insist a lot today that ketamine had a slight yellow color. I just want to ask you that. Is that true?
Objection,
No,
Your Honor.
however-
If I may.
Yes.
Oh, I already said that we're not concluding that there's a difference in colors between the two substances. With opposing counsel mentioning this, it is twisting the words of what the witness never even said on the stand. Therefore, this line of questioning should be excluded.
What's the objection, Mr. Sanchez?
Objection of ask and answer.
I'm going to overrule. Please proceed.
Yes, Your Honor.
Yes, Your Honor. Dr. Zuzak, I'll ask it again. Mr. Sanchez talked about how ketamine has a slight yellow color compared to lorazepam. Is that true?
No, but there are noticeable differences, such as the difference in odor. For example, ketamine has a sharper odor than lorazepam.
Okay, but if we just focus on sight, we can make it very clear. Ketamine and lorazepam, they look the same.
Yes, that's true.
Clear, colorless substances.
Yes, counsel, but even under pressure, medical professionals should always double check not just the label, but also the physical characteristics like the smell, like of the drug before injecting their patient.
So that sounds like a yes, they are clear, colorless substances.
Yes.
And let's also talk about a few more things we can agree on, because we can agree Mr. Henley was injected with the wrong substance.
Yes.
We can agree it was ketamine, not the lorazepam he needed.
That's correct.
We can even agree because of that injection, he died.
Yes.
But let's see if it was the hospital who mishandled the medicine. Because right here, I've got the book Wonder.
I'm sorry, could you repeat that, counsel?
Right here, I'm holding up the book Wonder.
Yes.
No, the cover looks right. Nothing seems really off.
Not to my knowledge, no.
But if I were to take this cover off, it would reveal that the book underneath isn't actually Wonder.
I'm not sure, counsel. Could you repeat that question, please?
The book underneath the cover Wonder is different. It's not actually the book Wonder.
Okay. Sure, yes.
It's safe to say this was mislabeled with the wrong cover.
Yes.
And that's exactly what happened in today's case.
Objection, Your Honor. Pursuant to Rule 403, misleading the jury, may I be heard?
Yes, go ahead.
Under Rule 403, the evidence must be excluded when its probative value is substantially outweighed by the danger of misleading the jury. Opposing counsel just showed that with a book cover and taking out the book cover, it's a different book and therefore it's mislabeled. And that is not exactly how these drugs work, as it is a more complex system. And it's misleading the jury by making the jury believe it's as simple as just taking out the cover of the book, so I have two different chemicals that are mislabeled. Therefore, it falls under Rule 403, misleading the jury, and should be excluded.
Response?
Your Honor, this is just an analogy to help the members of the jury understand what happened. It is not substantially more prejudicial than probative in any way. Rather, the probative value is showing the connection, how this was a mislabeled book, just like how there was mislabeled medicine in the hospital. It's just an analogy.
Your Honor, if I may?
Yes.
This just analogy is making it too simple for the jury, making them believe that it's going to be as simple as just taking up the cover of a book to differentiate two different chemicals. And that is not at all how chemicals work in a hospital. Therefore, it falls under Rule 403, misleading the jury, and should be excluded.
Response to that, Your Honor?
It's okay. What about this? So I do agree there's a misleading element to it. I don't think, I think a good remedy again will issue a limiting instruction to the jury saying, as Miss Law just told us, this is an analogy. This is not to be used for, okay, this is how simple it is to change. We're going to let members of the jury see this demo, but with that limiting instruction. Is that okay for both sides?
Yes,
Your
Your
Honor.
Honor.
Perfect.
So this mislabeled book, that's exactly what happened in today's case.
Yes, but even under pressure, counsel, medical professionals should, again, always double check not just the label they're injecting the patient with, but also the physical characteristics of the drug itself. But that's a yes to your question.
I'm not talking about Dr. Hornby right now. I'm talking about the hospital, because the hospital had mislabeled medicine.
That's right.
They kept a bottle of ketamine with the wrong label lorazepam stuck on it.
Yes, but counsel, that doesn't disregard the fact that there are still noticeable differences between the two drugs. But that's a yes to your question.
That's a yes. The hospital had a bottle of ketamine mislabeled as lorazepam.
Objection, Your Honor. Asked and answered. I believe the witness just said that's a yes to your question.
It's cross. I've given prosecution leeway. Well, I'm gonna give defense. Well, sorry, not prosecution, plaintiff. We can give some similar leeway here. But yeah,
Yes, Your Honor.
Doctor, the hospital keeping a mislabeled bottle of medicine, well, that's dangerous.
Yes.
That is a mistake that can be deadly.
Yes, but so is not double checking. But that's a yes to your question.
In fact, the mistake the hospital made, it did become deadly.
Yes, but it was also Dr. Hornby's fault.
Dr. Zuzak, I can't help but notice you keep shifting the blame back to Dr. Hornby. Let's find out why. Because the truth is, Dr. Hornby, well, he didn't have control when the hospital hired an intern.
That's right.
Dr. Hornby didn't have control when a hospital refused to fire that intern.
Yes, but counsel, it's entirely inappropriate for Dr. Hornby to have that same intern fill a syringe for them, let alone letting that intern fill a syringe without double checking its content. But that's a yes to your question.
The hospital refused to let her fire the intern. That's a yes.
I wouldn't say the hospital refused, but Dr. Hornby was convinced by his supervisor. Yes.
You say the hospital wouldn't let her fire the intern. Let's see if that's really true, because, Doctor, as we've well established, the intern filled the syringe.
That's right.
This wasn't the world's best intern.
No.
The interns made mistakes in the past.
That's right.
He filled the syringe with the wrong substance.
Yes.
And Dr. Hornby wanted to fire the intern for this mistake.
Yes, but based on my analysis of today's case, he didn't. And after all of that, he still let that intern fill Arthur's syringe.
She didn't fire this intern because the hospital wouldn't let her.
That's not my understanding of the facts of today's case, counsel.
Doctor, you read Dr. Hornby's statements.
Yes, I did.
You know, the hospital, her supervisor was like, don't fire her because she has connections.
Objection, Your Honor. Improper impeachment.
explain briefly.
We ask that opposing counsel ask the necessary questions for impeachment instead of just broadly stating the statement from the affidavit.
Response.
Your Honor, we are not trying to impeach right now. We are just trying to clarify the facts.
What's the question again? Just for me.
The intern had connections. That's why the hospital wouldn't let her fire her.
Your Honor, if I may.
Yes, why is that impeaching the witness?
Opposing counsel just quoted it. Then we amend our objection to 801 as is an out-of-court statement offered to prove the truth of the matter asserted, as they just proceeded to quote something from the affidavit. Therefore, it falls into 801, and I believe opposing counsel is trying to show the true value of these statements, that this conversation did actually happen. Therefore, it should be excluded.
Response.
Your Honor, there are no statements. We are referring to Dr. Zuzak's knowledge. It's been established that he read all of the affidavits, which means it is within his knowledge that the intern had connections. We are not bringing up any statements.
Your Honor, if I may.
Briefly.
They just brought this knowledge from an out-of-court statement of the affidavit, and they're offering to prove the truth of the matter asserted. And opposing counsel, whether they're saying it or not, they just quoted an out-of-court statement. And they're trying to show the true value of these statements to show that this conversation did in fact happen. Therefore, it falls under Rule 801 and isn't inadmissible.
Can you just repeat the question for me one more time, Ms. Law? I'm very sorry.
Your Honor, yes, one of the previous questions was asking about the affidavit, but the more recent one was the hospital wouldn't let her fire the intern because she had connections.
To try to keep away from the affidavit, let's stick to Dr. Zuzak's knowledge. I'm going to over the objection. Let's not try to quote directly out of the affidavit, but let's just, if you can, just, if, as you said, this is within his premise of knowledge, let's keep it to that.
Yes, Your Honor.
So, Dr. Zuzak, you know the intern had connections.
Yes.
And that is why the hospital didn't fire her.
Yes, that's why Dr. Hornby's supervisor, Dr. Sawyer, convinced Dr. Hornby to give the intern another chance.
So circling back, Dr. Hornby didn't have any control when the hospital refused to let her fire the intern.
I wouldn't say Dr. Hornby didn't have any control.
But she didn't control firing the intern.
That's true.
She didn't have control hiring the intern.
No, but she did have control of delegating the responsibility to an intern of filling a syringe. But no, she didn't have that responsibility.
And certainly, Dr. Hornby didn't have any control when the hospital kept mislabeled medicine.
No.
Thank you, Dr. Zuzak. Nothing further, Your Honor.
All right. Any redirect?
Yes, Your Honor, briefly.
Go for it.
Now, Dr. Zuzak, how much ketamine was in the syringe found in the autopsy report?
10 to 12 times the typical sedation dose.
Objection, Your Honor. Outside of the scope of cross-examination.
Response?
Your Honor, I'm just raising a previously brought up aspect of the examination. Therefore, it is not going outside of the bounds of this redirect.
Ms. Lowell, was this 10 to 12 times or anything about the syringe dose brought up on cross-examination?
No, Your Honor.
Mr. Sanchez, is that your understanding too?
Yes, I believe so, Your Honor.
In that case, I'm going to sustain.
Yes, sir.
Motion
Now,
to-
Dr. Zuzak, was Dr. Hornby ever
Tricky.
forced?
Sorry, go ahead.
Yes, sir.
I'm
Was
gonna let you finish this question and answer. I see that D has called time, so I'm gonna let you finish this last question and answer.
Yes, Your Honor. Was Dr. Hornby ever forced to make Finley Rivera's fill the syringe?
No, that was completely on her own discretion.
No further questions, Your Honor.
Perfect. All right. Any recross based on the redirect?
No, Your Honor.
All right. Well, Dr. Zuzak, you are excused. Okay, so we're gonna take a 5-minute break. I asked Ian, we don't seem to have a strict all loss. Obviously, everyone's still kept in their time constraints, so we'll take a 5-minute break and come back at 7:30 PST.
Your Honor, before we begin the recess, the plaintiff rests their case in chief.
Yes, of course. All right. Are both sides back and ready to proceed?
Yes, Your Honor.
All right, plaintiff. Perfect. Judges, once you guys are back, just give me a thumbs up. And I assume everyone's filled out their ballots, but if anyone needs, for some reason, some more time, just let me know. Perfect. Ellen, are you back?
I'm here.
Perfect. All right, sounds good. Defense, you may call your first witness whenever you're ready.
The defense calls Riley Kwan to the stand.
There we go. Whenever you're ready.
Would you please introduce yourself?
My name is Riley Kwan. I moved here from Britain as a wee little thing at 15 years old.
And what do you do for a living, Miss Kwan?
I work as an administrative coordinator at Langford Hospital in Tilly.
What do you do as an administrative coordinator?
I supervise rotations, sign off on intern hours, and make sure the paperwork is up to date. If the doctors are the heart of Langford, the administration is the veins. Most people don't notice us unless we get cloaked.
How long have you been at Langford?
About 12 years now. I started as a nurse, moved up to supervisor, and eventually into administration. I've done pretty much everything except operate on someone.
And how did you get into healthcare?
Well, it all started when my sister came down with a nasty case of measles. I sat by her bedside with a mask, of course, and nursed her back to health with some cracking good chicken soup, my famous recipe. After that, I knew I wanted to help people, but Now I just want to keep the hospital running.
How would you describe the conditions at Langford Hospital?
Chaotic, honestly. We take in more patients than our budget allows. The building is old, the equipment is dodgy, and working double shifts is common. We are understaffed and stretched thin.
What about the interns?
Interns are essential to keeping the hospital running, but the supervision ratio is rubbish. It's supposed to be 3 interns per person, but in practice it can be closer to 6.
Are these interns qualified?
Some are brilliant, but others I wouldn't trust anywhere near a hospital, let alone treating patients.
Do you know the intern Finley Riveras?
Yes, I've seen her around the wards, always wearing those smashing glasses of hers, and am aware of a connection to Arthur Henley and Dr. Hornby.
How would you describe Miss Riveras as an intern?
I like her. She's bright and hardworking, but she gets in her own way. She moves too fast, and it wasn't a secret she's made mistakes before.
Let's talk about February 16th, 2025. What was the hospital like that day?
In shambles. We were short 2 nurses in the East Wing, and the ER was backed up from a bus accident, and I hadn't been able to find a single replacement.
Did anything else happen that day?
Patient Arthur Henley died after he had been treated earlier that day. I remember that he was treated by Dr. Hornby and Finn.
After that, what were your responsibilities?
I had to create the incident log. I started by pulling the chart and medication log. Everything looked hunky-dory at first.
What changed?
Later, I received a lab report that showed that Mr. Henley had ketamine in his system. Ketamine isn't something that just sneaks in. It means something has gone seriously wrong.
What could have gone wrong?
Well, it is impossible
Objection, Your Honor. Pursuant to Rule 701, speculation, may I be heard?
Yes, you may.
Opposing counsel is asking a witness what could have gone wrong. Basically, asking a witness to guess what happened. Therefore, it falls under Rule 701 and should not be admissible.
May I respond?
Yes.
We believe that the testimony that Ms. Kwan is about to elaborate on is fully within her rationally based perception. She's testified that she's worked at the hospital for 12 years. She's been a nurse, a supervisor, an administrator. She fully knows how this hospital works, and she herself has taken many jobs within it. She is fully capable of taking the information that she has gained in her over a decade of experience and applying it to an event at this hospital.
Your Honor, if I may.
Response, Mr. Sanchez, can you explain specifically how this goes to speculating as to someone's state of mind?
The witness is speculating what could have gone wrong. Basically saying that there's no definitive reason what could have gone wrong. Is asking the witness to guess what the witness thought could have gone wrong. Therefore, it falls under Rule 701 and is speculation.
I'm going to overrule for now. I do think we've laid some foundation on this witness so that it's not completely, there's certainly a certain level of rationally based perception here. If it does get more egregious, Mr. Sanchez, I invite you to re-raise.
Yes, Your Honor.
So what could have gone wrong?
Well, it is impossible to say for sure. A large possibility is that the cleaning process that the syringes went through wasn't thorough enough.
What was wrong with the cleaning process?
A hospital is supposed to use an autoclave to clean syringes, which cleans via highly pressured steam. But it's had been bust for weeks.
What did the hospital do instead of using an autoclave?
We had to use a manual cleaning process using a chemical solution. But if it isn't done exactly, then residue can linger, especially highly
Objection, Your Honor.
concentrated solutions like ketamine.
Objection, Your Honor. Pursuant to Rule 702, calls for an expert opinion. May I be heard?
Which part? Go ahead.
Your Honor, under Rule 702, a witness may only testify as an expert if their specialized knowledge, skill, experience, training, or education will help the trier of fact understand the evidence or determine a fact and issue. And this question is asking the witness, a lay witness, about the technical standard for rinsing a syringe, which requires specialized knowledge in pharmacology or medical procedures. This witness is not offered or qualified as an expert in this area, and her testimony on this point would be improper expert testimony. Therefore, Your Honor, this testimony should be excluded.
Response?
Yes, Your Honor. We don't believe that this witness is an expert witness. All the information that they've gained is purely through their skill and experience that they've received in the hospital, which is why 702 doesn't apply to them. 702 is specifically about what experts may testify to, but as Mr. Sanchez said, Ms. Kwan isn't an expert, so it's not relevant.
Your Honor, if I may?
Yes.
Opposing counsel just asked about the manual syringes, to which the witness responded that if the rinse wasn't well enough, a residue could remain. And mind you, this witness has never cleaned a syringe in her life because she works as the administrative coordinator at the hospital currently. Therefore, she does not have the specialized knowledge or skill to testify as an expert witness to give her expert opinion. And therefore, Your Honor, this testimony should be excluded.
Response, Your Honor?
Final word.
If what they're saying, if what Mr. Sanchez is saying is that Ms. Kwan is not able to testify to this, we disagree with that. She's testified that she was a nurse for many years. She knows hospital protocols. She's received training to be a nurse. She now directs other nurses to know what they do. It's fully within her knowledge that to understand how a piece of machinery works that she knows about from her experience and to talk about it. If opposing counsel believes that her level of knowledge isn't enough to prove this for a fact, they can cross that. But it is fully within Ms. Kwan's knowledge to say this.
Your Honor, if I may?
Okay, so I think as of right now, what Ms. Kwan's testimony elicits is essentially, correct me if I'm wrong, but it's to a level that if a syringe isn't cleaned well, there's going to be residue. I think that's somewhere of what we're getting at. That level of expertise, I think, is okay for a layperson to talk about. And Mr. Sanchez, if Ms. Kwan starts talking about maybe some more things that delve into, say, and as you would argue, an expertise level, please re-raise. I think as of right now, a layperson can tell us if a syringe isn't washed, there's going to be residue.
Yes, Your Honor.
Okay. What did the hospital do instead of using an autoclave?
Like I said, we've been using a chemical solution for a manual cleaning process. And if it isn't done exactly, then residue can linger on it.
Did you raise concerns about the new cleaning process?
Yes, I did. I emailed the facilities director 3 times. I even had a letter to the charge nurse that
Objection, Your Honor. Pursuant to Rule 801 hearsay, may I be heard?
Yes, what statement, please?
Hearsay is any out-of-court statement or document offered to prove the truth of the matter asserted. Now, the witness just referenced some out-of-court emails that she had made to her advisors. And I believe these are out-of-court statements that opposing counsel is trying to show the true value of, that the witness did actually email these advisors. Yet these are still out-of-court statements offered to prove the truth of the matter asserted. Therefore, they fall under Rule 801 hearsay and should be excluded.
Response, Your Honor?
Yes.
These emails aren't statements. Statements need to be an actual assertion. All this witness testified to is she sent an email to do something. She didn't even state a single word that was in that email. There was no statement said.
Your Honor, if I may?
Very briefly.
Hearsay also does apply to any out-of-court documents offered to prove the truth of the matter asserted, as the witness just referenced and made a statement referencing out-of-court emails that they had emailed to their advisors. And like I said, opposing counsel is trying to show that this actually happened. They're trying to show the true value of this statement, and therefore it should be excluded under Rule 801 hearsay.
I'm going to overrule the objection. I don't believe in this scenario sending an email is any dissimilar from using a lawnmower or picking up a phone. They are actions inherent without any truth value. Now, if the contents of that email is discussed, that could be a potential hearsay issue. I'm going to overrule.
Yes, Your Honor.
So did you raise concerns about the new cleaning process?
Yeah, like I said, I emailed the facilities director 3 times, and then I even had a laugh with the charge nurse that it was going to bite us, but um, I never meant it like this.
In your experience, how does a hospital like Langford contribute to incidents like this?
Hospitals are chain reaction environments. When one thing goes wrong, like staffing shortages, broken equipment, or an overwhelmed intern, everything down the line fails. It's not as neat as it being a single person's fault.
Thank you. Your Honor, no further questions.
Cross.
Yes, Your Honor. Joey Sanchez for the plaintiff. May I inquire?
Go for it.
Now, Ms. Kwan, you are the administrative coordinator at Langford Hospital, correct?
Yes, I am, sir.
And as the administrative coordinator, you oversee which physicians are assigned to patients, yes?
Yes, I am.
So you are aware that Arthur Henley is Dr. Hornby's uncle, correct?
Yes, I am, sir.
And hospital policy, it usually discourages physicians from treating family members, doesn't it?
Yes, sir, it does.
Yet despite that policy, you still let Dr. Hornby be responsible for Mr. Henley's care. Isn't that right?
Yes, because Mr. Henley requested it.
Yet he is still a family member and breaking policy. Isn't that right?
Yes, sir. But
Now
we always
let's talk.
tended to the patient. I'm sorry for cutting you off.
Now let's talk about that responsibility. Because, like you said, Dr. Hornby was the attending physician, correct?
Yes, sir. She
And
was.
as the attending physician, she alone was responsible for supervising the interns. Isn't that right?
Yes, sir. She was.
And Dr. Hornby sent intern Finley Rivera's to prepare the syringe, correct?
Yes, sir. She did.
And Ms. Kwan, you personally believe that Rivera's wasn't the best intern, right?
No, sir. But I did like her.
Now, didn't you just state in direct examination that she would sometimes get in her way and make mistakes?
Yes, I did, sir.
So you would agree with me that Rivera's wasn't the best intern?
No, sir. But interns are always there to learn, so.
But she would make mistakes, isn't that right?
Yes, she would.
And doctors are supposed to supervise interns.
Sorry, could you repeat the question?
That doctors are supposed to supervise interns.
Yes, sir, they are.
But Dr. Hornby did not personally double-check the syringe before it was administered, did he?
I don't know, sir.
Dr. Hornby, didn't he tell you right after the incident that he should have checked it himself?
She did.
Meaning that he didn't double-check.
Well, I don't know, but she said she did then. Yeah.
But it was Dr. Hornby's responsibility to verify the contents of that syringe, correct?
Like I said, sir, yes.
And that responsibility, just to make clear for the jury, it did not belong to the intern, did it?
Well, no, I don't think so.
That's a yes to my question?
Well,
that it did not
yes,
belong to the intern?
sorry, yes. Yes, it doesn't fall to the intern.
Now, going back to what Dr. Hornby told you after the incident, he admitted to you that he should have checked the syringe herself.
Yes, she did.
Now, she didn't say it once, did she?
No, sir.
She didn't say it twice.
No, sir.
In fact, Dr. Hornby told you 3 times that she should have checked it herself. Isn't that right?
Yes, sir, she did.
That's all, Your Honor. No further questions.
All right. Any redirect based on that cross-examination?
No need, Your Honor.
All right. Well, give us a second again to fill out ballots. A thumbs up again, and Mrs. Kwan, you are excused. All right, everyone good? Perfect. All right, defense, call your second witness.
Yes, Your Honor. We call Dr. Elias Hornby to the stand. Good evening. Could you introduce yourself to the court?
Good evening. My name is Elias Hornby.
What do you do for a living?
Well, I'm the attending physician at the Langford Hospital, and I specialize in internal medicine. I'm also the full-time mother of my lovely boy Jamie, and I live right here in Tilly with my husband.
Well, doctor, how'd you get into your line of work?
Well, I actually started out studying molecular biology. But when my mom was diagnosed with lung cancer back in 2003, I saw what a good physician could do for a family. And that's when I knew I wanted to be the one giving that care.
So, where'd you go to school?
I went to the University of Tilly to get my bachelor's, and then I got my medical degree from the Tilly School of Medicine. I then went on to complete my residency and fellowship at the Little Hamlet General Clinic.
Can you tell us about your professional experience?
Of course. After getting my medical degree, I worked at the Langford Hospital since 2017, and I've been actively practicing medicine for 13 years now.
Now, before we go any further, doctor, do you know why you're in court today?
Yes. They're blaming me for my uncle's death.
Ma'am, we heard the plaintiff say today you took a grave risk without a good reason. Is that true?
No, ma'am. It's not true. Listen, I've spent my entire life saving people. I never skip safety checks because that's the safety of my patients on the line.
Now that we've got that cleared up, let's spend some time talking about your professional background. What's it like working in the hospital?
It's exhausting. We're always busy, so our staff is constantly overworked. I mean, I've had to take on more interns than I can manage just to keep that hospital running.
To your knowledge, is this consistent throughout the hospital?
Yes. We rely on interns, even if they aren't qualified to treat all the patients. And our hospital isn't the best, so our equipment is old and we all work double shifts. It's a hard job, but I would choose it over anything else. Because I know I can make a difference in people's lives. Until the day I treated my uncle. February 16th. That's a day I'll never forget.
Can we talk more about that day? Is that all right with you, ma'am?
Yes. Yes, I need to clear the air.
Okay, doctor, so what happened February 16th?
It was supposed to be a routine checkup. It was a routine checkup. My uncle needed his treatment for mild anxiety, and I was the one giving it.
Is it normal for you to be treating your uncle?
Not exactly. Normally, they don't have family members treat each other, but the hospital was so understaffed that they needed me to do it. and my uncle requested it, so I went.
And how did you treat your uncle that day?
He needed an injection of lorazepam, so I gave my intern very clear instructions on how to fill that syringe with the right drug. And then I looked it over and gave my uncle the injection.
Would you recognize a picture of the syringe you used if I showed it to you today?
I would.
Your Honor, let the record reflect we're going to be screen sharing Exhibit 3. Ma'am, is that a fair and accurate copy of the syringe you used?
Yes, this looks like a picture of the syringe I used.
At this time, the defense moves to enter Exhibit 3.
Objections?
None at this time, Your Honor.
Cool. So entered.
Doctor, did you have any reason to believe this syringe was filled with anything other than lorazepam?
No, none. I needed lorazepam. It was handed to me as lorazepam. There's nothing else to indicate otherwise.
And were you able to double check this syringe?
Yes, as always. I looked it over. The color looked exactly like lorazepam, so I injected it.
And now just looking at this syringe, would you be able to smell through that plastic?
Smell? No, of course not. Syringes are sealed for a purpose. Sterility.
So do you know what went wrong that day?
Oh man. I have no idea what went wrong. The label on that syringe was accurate, no doubt. I remember it said lorazepam, not ketamine. I'm sure.
Thank you, co-counsel. We can get that exhibit down. So who did fill that syringe?
My intern did. Finley Riveras.
Did you have any concerns about your intern?
Of course I did. Rivers has made mistakes before, mistakes that put the lives of my patients in danger. When she filled a syringe with the wrong drug, I wanted to fire her.
Objection, Your Honor.
As to?
Pursuant to Rule 404, may I be heard?
Yes.
Your Honor, pursuant to Rule 404, evidence of a person's character trait cannot be used to prove that they would act on that character trait again. Your Honor, the witness is testifying to an instance to which Ms. Rivera's filled the substance, the medication, wrong. Your Honor, we believe that opposing counsel will be using this to prove that Ms. Rivera did this once and they would do it again. Therefore, it's inadmissible in today's case.
Response?
Your Honor, while we don't have a court reporter today, we do believe in the very first plaintiff examination, it was brought up that Finley Rivera's made mistakes in the past and how she is an untrustworthy intern. That fact has been very consistent throughout all of the examinations today. And since the plaintiff opened the door, the defense is allowed to refute that and to use the evidence as we wish.
Response to that, is that your understanding too, Miss Alfonso?
Yes, Your Honor. While we understand that the door was opened, there was never any usage of that character trait being used to prove that they would act on it again, Your Honor. We believe that the defense will be trying to use the fact that Finley Rivera made the mistake to prove that she did it again, and that that is why the medication was mixed up.
But plaintiff attorney, correct me if I'm wrong, but haven't you also been asserting the fact that, this intern was making mistakes left and right? Was that your assertion as well?
Your Honor, we on direct examination did not bring up the fact that she had made a mistake prior. That was on cross-examination. Your Honor, we never used that character trait as proof that she would act on it again. Now it is being brought up that she would act on it again, and it's therefore inadmissible.
Response.
Your Honor, we're not trying to prove Finley Rivera's is going to make mistakes again. Rather, we're using it for the exact same purposes as Miss Alfonso and the plaintiff, that it shows she has a character of making mistakes. That has been well established throughout this entire trial. The door was opened by the plaintiff previously, and that is still what we are using it for.
All right. I'm gonna again. I feel like I'm limiting. I'm showing a lot of these, but let's keep it to th this is fine. But if we're Miss Alfonso, if you do realize that they're using it for propensity evidence, please re-raise.
Yes, Your Honor. Dr. Hornby, I'm just going to re-ask my question. Did you have any concerns about your intern, Finley Rivera's?
Of course. Man, when Finley filled the syringe with the wrong drug, I wanted to fire her. My supervisor told me to give her another chance.
What do you mean by that?
Her family has connections with my supervisor. Apparently, her parents were residents.
Could you have fired your intern if you wanted to?
No. As a physician, I don't have a say in who gets hired or fired. That's all decided by my supervisors and hospital admin.
So why did you choose Finley Rivera's to fill the syringe?
Ma'am, I didn't. I didn't have a choice. She was the only intern I had at the time who was available. And as doctors, we must give interns the opportunity to participate in work.
So looking back, what do you know about the events leading to Mr. Henley's death?
Ma'am, it's scary. Oh, I did everything in my power to make sure my uncle was safe. But it was useless. I gave my intern the simplest of jobs. Take a clean syringe from the rack, fill it with the raspam. And then when I found out my uncle's death, I did everything in my ability to find out what went wrong.
Ma'am, what did you discover?
I found that there was ketamine in the bottle, not lorazepam. And then I find out that the medicine's been mislabeled. Man, I trusted our hospital to keep our patients safe. If only I didn't, my uncle would still be here today.
Thank you so much for your time today, Dr. Hornby. Your Honor, we have no further questions.
Cross-examination.
Yes, Your Honor. Isabel Alfonso for the plaintiff. May I inquire?
Go for it.
Now, Dr. Hornby, you just testified on direct examination that you looked over your intern's work when she prepared that syringe.
Sorry, that's right.
You testified that you double-checked that syringe.
That's right. I did.
Is that your sworn testimony in today's case, Dr. Hornby?
That is. I'm always sure to double check anything that intern gives me.
Dr. Hornby, you remember making a sworn statement before today's case.
I do.
In that statement, you told the truth.
That's right.
You included all relevant and pertinent information.
That's right.
You had up until the start of today's trial to make any changes.
I did.
And you would recognize it if I were to show it to you.
I would.
Your Honor, permission for the plaintiff's tech, Ms. Gutierrez, to screen share the affidavit of Dr. Hornby?
Go for it.
Now, scrolling down to lines 89 and 90. This is your affidavit, correct, ma'am?
That's right.
If we go back to the top, that is your name there, isn't it?
That's right. That's my name, Elias Hornby.
And if we go to the bottom, your signature is there.
Right there, yes.
This is a true and correct copy of your affidavit.
It is.
It has not been changed or altered in any way, shape, or form.
No, ma'am, it hasn't.
Now, directing the court's attentions to lines 89 and 90, please read it to yourself while I read aloud. Oh, my apologies. My tech, please scroll down to lines 140. Excuse me, I apologize for the delay. Ma'am, if you could continue scrolling, I apologize. Back up.
Ma'am, if I could direct your attention to a line.
Yes, I would appreciate that, ma'am.
Of course, ma'am. Miss Gutierrez, please scroll up to line 38. Ma'am, I say right there. I became even more vigilant on double checking the contents of everything my intern did. And that day, ma'am, I did double check what Finley Rivera's handed me.
Ma'am, if we could scroll down to the lines where you were speaking to Riley Kwan, Miss Gutierrez, if you could please scroll down. Please stop. Redirecting your attention to lines 82 to 83, ma'am. Please read to yourself while I read aloud. Later that day, I ran into Riley Kwan. I remember telling them more than once I should have checked it myself. Am I reading that correct?
That's right. I was referring to the bottle, and when I had Finley Rivera's fill that injection of lorazepam. After Finley handed it to me, I made sure to check the syringe. But I wish, ma'am, I wish I checked that bottle so that at least I could smell it.
Ma'am, redirecting you back to my original question, you testified that you looked over your intern's work.
That's right, I did.
So that would include the preparation of the syringe.
My apologies, ma'am.
That would include the preparation of the syringe, correct?
No, ma'am. I was filling, or rather, I was at another patient at that time in another part of the hospital. I directed Finley to fill that syringe with lorazepam.
Ma'am, where here did you ever say
Your Honor.
that you were with another patient?
Your Honor, hearsay in the form of improper impeachment, if I may be heard.
Yes. Please explain.
Your Honor, at this point, it's been very well established there is no contradiction. Dr. Hornby has directed the courts to line 38 that explicitly says that she double checks everything her intern does, and that means the syringe. And the contradiction Miss Alfonso seems to be referring to is something different. Dr. Hornby was referring to the bottle back then, but really she double checked the syringe.
Response,
Ms. Alfonso? Yes.
Yes, Your Honor. First and foremost, we were about to impeach by omission because never in this affidavit did Dr. Hornby mention that they were taking care of another patient other than Arthur Henley at the time of treatment. And furthermore, in this affidavit, it doesn't say that I should have checked the bottle. It said I should have checked it myself, it being the syringe, because Dr. Hornby never checked the syringe that Finley Rivera's handed her, and Dr. Hornby never checked the bottle that Finley Rivera's prepared. And Dr. Hornby just testified that she overlooked her intern's work the day of the accident, Your Honor.
Response to that?
Yes.
Just focusing on the impeachment going on right now, Your Honor, Dr. Hornby wrote this statement herself. When it said, I should have checked it myself, Dr. Hornby is really the only one who knows what it refers to. And she says it refers to the bottle, not the syringe as Miss Alfonso wrongly believes. And it very clearly says in her own words that she double checks everything the intern does. That is in her affidavit. This is an improper impeachment.
Response, Your Honor?
It's okay. I think Miss Law, I'm gonna leave it on the record for the jury to decide. I do believe you make a point, but also I do believe the jury can decide for themselves the weight and the exchange. So I'm gonna overrule.
Yes, Your Honor.
Now, Dr. Hornby, you mentioned on direct examination that Mr. Henley passed away during a medical procedure.
That's right, ma'am.
And you were the doctor who conducted that procedure. Isn't that right?
That's right.
He was your patient.
That's right, ma'am.
He died to the injection that you administered.
That's right. I administered the injection, but I was not the one to fill that syringe, no.
The medication you believed to be lorazepam.
That's right. It looked like lorazepam, so I injected it.
Well, ma'am, you've been here throughout the entirety of today's trial.
I have.
You were present for the testimony of Dr. Alex Zuzak.
I was, yes.
You heard that Mr. Henley passed away from a lethal overdose of ketamine.
That's right. I was shocked to hear that the vial I injected had ketamine in it, so I sent that vial for testing, and it turns out, even though that vial was labeled lorazepam, there was ketamine inside.
But doctor, just to make things clear, Mr. Henley was not administered lorazepam.
I'm sorry?
To make things clear, Mr. Henley was not administered lorazepam.
That's right. Henley was injected with ketamine.
The ketamine you injected into him.
That's right. I did not know it was ketamine at the time.
Well, let's talk about whether administering that medication was preventable. Because you weren't the one who prepared that syringe. Isn't that right?
No, ma'am. I told my intern, Finley Riveras, to fill a syringe with lorazepam.
Exactly. Your intern who works under you, correct?
That's right.
An intern who does not have a medical license.
Interns do not have medical license. They are medical students, ma'am.
An intern who was your responsibility.
That's right.
And you did not request for any other medical staff to assist in preparation.
No, ma'am, I couldn't request for any medical staff. I only had my interns.
You didn't choose any other one of your interns to carry out that task either.
Finley was the one with me that day, yes, ma'am.
Well, let's talk about whether choosing Finley Riveros was a risk or not. Because Finley Riveros had once filled a syringe with the wrong substance.
Of course, ma'am. I wanted to fire her for that. Hospital admin wouldn't let me.
Exactly, you were so angry you almost fired her on the spot.
Of course, ma'am.
Yet even after all of that, you still let this intern prepare Mr. Henley's medication, didn't you?
That's right. Finley was the one with me that day, and that's why I took extra care to check the syringe I was given.
Well, ma'am, we already established that you didn't check that syringe, right?
Ma'am.
Well, let's move on because you chose to have Finley prepare that syringe instead of doing it yourself.
That's right. We're quite understaffed, and it's normal to let interns fill syringes.
And you would say that after the incident with Finley, you became more vigilant about double checking everything the interns did.
Of course, ma'am, I've been telling you.
Up until the procedure that killed Mr. Henley.
Ma'am, I became extra vigilant on checking everything Finley gave me because Finley filled the wrong drug in the wrong syringe.
Ma'am, redirecting you back to my question, you double-checked up until the procedure that killed Mr. Henley, right?
Double-checked the syringe that Finley gave me, yes, ma'am.
Well, since you say you do, let's see if you took precautions to ensure that the intern filled the correct medication. Because the night before, you knew that she went out partying with a few friends at a sorority.
No, ma'am. Now sitting in court, I know that Finley did go partying, yes.
Ma'am, is it your sworn testimony today that you did not know that Finley was partying out the night before?
Ma'am, she seemed swaying on her feet. I assumed something was up. Yes, ma'am.
Ma'am, again, it is your sworn testimony today that you did not know that Finley went out partying the night before at a sorority.
No, ma'am.
Is that your sworn testimony in today's case?
No, ma'am.
So you did know that she went out partying the night before at a sorority?
I knew she went to some sort of gathering that left her wobbly on her feet.
Ma'am, is that your sworn testimony in today's case that she did not go out partying at a sorority and it was just some gathering?
No, she did go out partying. That's what I heard today. Yes, ma'am.
And you claim you didn't know the day of the incident?
She looked, ma'am, I've told you, she was swaying on her feet.
Ma'am, I'm not asking you if she was swaying on her feet. I'm asking you if she told you that she went out partying at a sorority. Yes or no?
She did, yes.
And you can't tell us for certain if she had alcohol the night before Mr. Henley's death, right?
I cannot tell you that, no, ma'am.
But as you just mentioned, you noticed she was swaying on her feet.
Yes, ma'am, that's what I just told you.
Blurring her words.
That's right.
And she even told you she was feeling a bit dizzy.
That's right.
But even then, you still told Mr. Veras to prepare the medication.
That's right. Miss Rivera's was the intern with me that day, so I told her to go fill that medicine.
And you were not next to your intern when she prepared that medication.
No, ma'am, I don't personally watch like a hawk over my interns' backs when they fill medicine.
So you don't know for certain if they grabbed the wrong medication.
Ma'am, I'm sorry?
You don't know for certain if she just grabbed the wrong medication.
No, I don't. However, when I looked, it did look like lorazepam, and when I later checked the bottle, it was labeled lorazepam, ma'am.
Right, ma'am, but had you been in that preparation room, you would have been able to smell the ketamine while preparing the syringe, isn't that right?
That's right.
And Dr. Hornby, you know that the key difference between lorazepam and ketamine is their smell.
That's right. Their smell.
And when you were about to eject Arthur Henley, you didn't double check your intern's work by just squeezing a little bit of the medication out of the syringe, did you?
Ma'am, that would decrease the dosage.
Well, ma'am, you were here throughout the entirety of today's trial, right?
I was, yes, ma'am.
So you heard that either way, the dosage was off completely, isn't that right?
No, ma'am. At the time, I believed the syringe to be lorazepam.
Well, ma'am, I'm not asking you about at the time, I'm asking you about today. That is what you heard, correct?
That's right. The dosage for ketamine would have been off, but the dosage for lorazepam would have been just right.
All right, ma'am. I want to talk to you about who's responsible for the death of Mr. Henley, because at the end of the day, you are the attending physician.
That's right. I was my uncle's attending physician.
So ultimately, administering proper treatment is your responsibility.
That's right. Administering treatment, yes, ma'am.
And so is preparing, correct?
No, ma'am.
So you would have the members of the jury believe that it is not your responsibility to prepare your patient's treatment?
Ma'am, as I told you, it's not the physician's responsibility to prepare the syringe. It's only the physician's responsibility to administer it.
All right, ma'am. And you'd agree that it is your duty to provide him with the best medical care possible, right?
Of course, ma'am, and I tried to do that to the best of my ability.
But you'd agree with me that you didn't.
I'm sorry?
You'd agree with me that you didn't.
No, ma'am, I would not.
Well, you say that even though you didn't check that syringe.
I checked that syringe.
All right, ma'am. You said yourself. I should have checked it myself, but
I should have checked the vial myself, yes, ma'am. I should have been there when Finley was filling it, yes, ma'am.
exactly. So you agree that you should have checked that medication yourself.
I did check that medication, ma'am.
At this point, asked and answered. We've had a whole impeachment about this. Miss Alfonso has gotten several more questions out. At this point, it's asked and answered.
Response, Your Honor?
Briefly.
I'm simply having the witness clarify because she has not given me a direct answer on whether or not she has checked it. And one moment she'll say yes, and one moment she'll say no. So I'm just clarifying for the members of the jury whether or not she actually checked that medication herself.
Your Honor, if I may.
It's fine. I'm gonna continue the same thing that whenever an asked me answered is let's one more question. I'm gonna instruct Ms. Hornby to give a yes or no. Did she check the syringe? And let's move on from this question.
Yes, Your Honor.
Dr. Hornby, you'd agree that you should have checked that medication yourself.
I did check the medication myself.
Thank you. No further questions at this time, Your Honor.
All right. Any redirect?
Yes, Your Honor. Dr. Hornby, I know you've just been asked this a lot of times, but I want to make it very clear to the court. Did you double check the syringe the intern handed you?
I did, ma'am. Yes.
Thank you. Nothing further, Your Honor.
All right. Perfect. All right. Any requests based on that redirect?
None at this time, Your Honor.
All right. In that case, defense, we'll let Ms. Hornby return to her, albeit virtual counsel table, and I assume you rest your case in chief.
Yes, Your Honor. We do rest.
Perfect. All right. We're gonna take a 4-minute recess. We're gonna come back at 20, whatever time zone everyone is in. Yeah. We are back onto the record. Plaintiff, are you ready for closing arguments?
Yes, Your Honor. Isabel Alfonso for the plaintiff. May I proceed?
Whenever you're ready.
May it please the court, Your Honor, opposing counsel, members of the jury. She took a grave risk without a good reason. Think back to that mechanic that you trust with your car. You trust them to check everything and make sure it's safe. Instead, they pass the responsibility to an assistant, ignores every safety protocol, and sends you on your way. That is what happened to Arthur Henley. Except instead of a mechanic, he trusted a doctor, Dr. Elias Hornby, who handled a critical task to an intern without supervision. And in doing so, she took a grave risk without a good reason. Today, we, the plaintiff, have decided to file a suit against Dr. Hornby for medical malpractice and wrongful death. And what that means is that we had to prove every single one of these claims by a preponderance of the evidence, that it is more likely than not Dr. Hornby is liable. To prove medical malpractice, we had to prove 3 elements. That Dr. Hornby owed a duty of care to Arthur Henley, that Dr. Hornby breached that standard of care, and that that breach was the proximate cause of harm done to Henley. And to prove wrongful death, we had to prove 3 more elements. That Arthur Henley died, that the wrongful act of the defendant caused his death, and that the plaintiff suffered a compensable loss as a result. Ladies and gentlemen, we are confident that we met our burden and proved to you every single one of these elements by a preponderance of the evidence, because she took a grave risk without a good reason. You heard today that Arthur Henley was under Dr. Hornby's care, and that she breached that standard of care by taking risks. Let's talk about it. Because you know that it was Dr. Hornby's job to prepare the medication and to double check that medication. The medication she was injecting into Mr. Henley was the right one. Because it is her responsibility to ensure that Mr. Henley receives proper care. Not her intern, not the hospital. Her. Arthur Henley passed away due to a ketamine overdose, but not of small traces of ketamine, but of 10 to 12 times the lethal dosage. You heard it from Dr. Zuzak, an expert in toxicology and pharmaceuticals, that Arthur was injected with the completely wrong substance and the wrong dosage of that substance, a substance that killed him. And why did this happen, members of the jury? Because Dr. Hornby took a grave risk. She didn't oversee the filling of the syringe. Instead, she sent Finley Riveras, an intern under her supervision, under her responsibility to prepare treatment, with vague instructions and a rushed environment, telling her to be quick about it. And Finley did as she was told, trusted that the syringe Dr. Hornby told her to get was clean, because it was Dr. Hornby's responsibility to make sure it was. Dr. Hornby also did not even bother to double check the medication herself. Members of the jury, you heard her inconsistencies on that stand. She told you that she checked the syringe, but you know she didn't, because she said it herself to her coworker, Riley Kwan. I should have checked it myself. She wants you to believe it's the bottle, but it wasn't only the bottle she failed to check. It was every step of the procedure. She handed the work off to an intern and didn't bother to check what she was injecting. Because if she had, with just one little squeeze of the medication, like every doctor does, she would have known it was ketamine, not lorazepam. Had she bothered to check that syringe and chosen not to take a grave risk, Arthur Henley would still be here. Ladies and gentlemen, we showed you today the negligent actions of Dr. Hornby and the clear breach in the standard of care. And because of that breach, Arthur Henley is dead. a breach that could have been avoided if Dr. Hornby did her job. But instead, she took a grave risk without a good reason, breaching the standard of care and directly and proximately causing the wrongful death of Arthur Henley. That is why we ask you, members of the jury, to find the only verdict the law and evidence support, a verdict of finding Dr. Hornby liable. Thank you.
Thank you, Ms. Alfonso. Ms. Lowell?
Yes, Your Honor. The hospital mishandled the medicine. The plaintiff just came up here and gave an analogy. A mechanic working on a car, but they left a few details out of that story. Because that mechanic was a trusted, reliable worker who's been at their job for a couple decades. Now, she was doing a routine checkup with a regular client when everything goes wrong. She fills the tank with what she thinks is gasoline, but actually mislabeled isopropyl alcohol. Her boss forces her to work with an intern, and despite all the instructions she gives, the intern makes mistakes. That mechanic lived through the exact same scenario as Dr. Hornby. Because Dr. Hornby was blamed for the mistakes of the hospital. Mistakes the hospital made when they mishandled the medicine. Now, the plaintiff said today, again and again, she took a grave risk without a good reason. They're wrong. Because it was the hospital who took a grave risk when they mishandled the medicine. It was the hospital who took grave risks for profit, not the doctor. But that's still why we're here in court today. Because the plaintiff has something to prove against Dr. Hornby. They have a burden to prove more likely than not my client committed both medical malpractice and wrongful death. And really, what that means is if this case comes down to a 50-50 split and you don't know what to choose, well, then you gotta go with not liable. Members of the jury, they failed to meet that burden this entire trial with the same three facts: the mislabel, the mistake, and the mishandle. First, this mislabeled medicine. Members of the jury, you learned today from the plaintiff's own expert witness on cross-examination that the hospital kept mislabeled medicine. They had a bottle of ketamine with the wrong label lorazepam stuck on. Members of the jury, I don't need to tell you how dangerous that is. It is the equivalent of mislabeling poison as dog food. It is dangerous, it is deadly, and that is what killed Arthur Henley. But second, to add the cherry on top, the mistakes the intern made. Because every single witness who testified today had something bad to say about that intern. Because that intern who assisted Dr. Hornby was completely incompetent. They misfilled syringes in the past, forgot to sanitize them properly, made all sorts of mistakes that should have gotten her fired. So finally, let's talk about how the hospital mishandled this whole situation. Because you heard from several witnesses today. Dr. Hornby wanted to fire the intern. But the hospital wouldn't let her. Because that intern just had too many connections. These aren't the mistakes of a doctor, but the mistakes of a hospital who mishandled the medicine and mishandled the whole situation. Now, the plaintiff also brought up the three elements they have to prove to meet their burden. Let's go through them one by one. First, they had to prove Dr. Hornby owed a duty of care. And yes, we agree with that. Dr. Hornby had an obligation to take care of Mr. Henley. But we want to make it clear, she is not all-knowing. There is no way Dr. Hornby could have known they had a bottle of mislabeled medicine. She handled the situation in the best way possible, giving the intern very clear instructions, double-checking the syringe to the very best of her ability, and then administering the treatment. Second, they talked about how Dr. Hornby violated the protocols. But we want to make it clear she didn't. She trained the intern because the hospital hired and forced the intern on her, even if that intern kept making mistakes. And she gave that intern a task because Finley Rivera's was the only intern available. And of course, knowing Finley Rivera's made mistakes, Dr. Hornby checked the syringe before injecting it. Now, Miss Alfonso kept bringing up her attempted impeachment that didn't go through. because it clearly said in Dr. Hornby's affidavit she double checks everything the intern does. That includes the syringe she was handed to by the intern that day. Now, the statement, "I should have double checked it," she's talking about the bottle, not the syringe. Dr. Hornby wrote her affidavit. She knows best, not Miss Alfonso. We want to make it clear. Dr. Hornby herself testified today the physician isn't responsible for filling the syringe. She's responsible for administering it. It is perfectly all right for her to tell her intern to fill the syringe. She double-checked it. She followed protocol to the letter. So finally, they talked about the breach and how that caused harm to Mr. Henley. It wasn't Dr. Hornby's breach that caused the death of Arthur Henley. It was the hospital. The same hospital who mishandled the medicine. Now, members of the jury, I just want to take a moment and think about Dr. Hornby as a real person. Because she's human, just like the rest of us. She makes mistakes, but that doesn't make her negligent. Because members of the jury, I want you to remember, Dr. Hornby had no control over the mislabeled medicine. Dr. Hornby had no control over the intern's mistakes. The people who did have control were the hospital. And they made the mistakes when the hospital mishandled the medicine. Find Dr. Hornby not liable. Thank you.
Thank you, counsel. Rebuttal? And timekeepers, just let us know how long. I believe the rebuttal is, how long is the rebuttal? Let's see. I actually don't see it here, but if timekeepers could tell us how long the rebuttal is, that'd be great. Oh, I see it there. 39 seconds. There we go. All right.
Proceed, Your Honor.
Go for it.
Miss Liu just came here and told you that the hospital mishandled the medicine. But Dr. Hornby mishandled her responsibility because she took a grave risk without a good reason. They talked about the hospital mislabeling, but ladies and gentlemen, just because the hospital mislabeled a bottle doesn't negate Dr. Hornby's breach and failure. They mentioned a mistake, and they blamed Dr. Hornby's intern for her mistakes. But this unlicensed intern was under Dr. Hornby's supervision and her responsibility. And they talked about mishandling, but she's the one that failed to follow protocol and didn't bother to check the preparation of the syringe itself. Because the impeachment wasn't failed. You heard the inconsistencies out of her mouth. And when you look at the facts and evidence, you see the clear breach and the death that breach caused. Find Dr. Hornby liable. Thank you.
Thank you, counsel. All right. So that concludes the trial. Great job at both teams. I'm going to give judges a second to submit their ballots. Make sure, there's nothing that's not filled out. Well, on this ballot, everything's marked as required, so just make sure you don't mark anything wrong. And don't forget to nominate one attorney and witness that's most outstanding by name. Once we get the all clear from Ian, or he says start comments when they all say submitted. Cool. So we'll wait for everyone to just verbally give me the all clear. I will be submitting right after I finish this captcha. Perfect. Take your time with comments. Just let me know when you're done. And actually, if everyone could just turn on their cameras, every competitor, so that the judges might be easier to just identify, especially nominating the so-called MVPs.
I'm submitted.
Thank you.
Okay, okay, hold on. I thought I submitted, but I have to do select images with stairs.
Wait, no, so real. I got the bus one. That was easy. I hate the traffic light ones
Okay,
because
I failed it. So
okay.
hold on. Okay, I'm good. I submitted.
Okay.
Okay, I've submitted as well.
Okay, sounds good. We can start with comments. I don't want to say the whole spiel about I've been talking the whole time. Let's just assume that's been said. But yeah, I'll go again by the order on my screen. Lydia, do you want to start?
Yeah, what are we giving them? Is it general comments right now?
I think anything is fine, really. I mean,
Okay.
I'm assuming we get the all clear.
Okay, so I'm just gonna have two big points for well, maybe three big points. I think everyone could have benefited from being slow. You guys had a lot of incredible things. I remember I was freaking out because I did mock trial in high school and it was nothing like this. So, I mean, I wrote to Ian, I was like, if I was like this in high school, I would be unstoppable. So good job to all of that. But with that in mind, there was a couple of things I thought that could be enhanced. One of them was the slowness. I thought you took away your own moments by not going slow enough and like pausing long enough and letting them sit. I think another thing in terms of performance is something I tell my students when I coach a lot, is that you can be both professional and personable. A lot of people think professional means, just getting up and being super passionate or maybe super serious or super indignant. But it could also mean smiling. It could also mean being friendly. That's that personable aspect. Because a lot of people can be professional, but when you become personable, you become likable to the jury. So that's something that I would have loved to see from all of you. You guys all have beautiful like personalities. I got to see some of it when you let it leak through. And I think you could have just been so much more natural in yourself if you had just, allowed yourself to smile a little, maybe be yourself a little bit more. In terms of theory, I have just one thing for P and one thing for D. I think for me, I don't know anything about the case, so I could be saying something wrong and it might not have actually worked out. But I think legally, what I was missing is what it was that was the breach of duty that this doctor did. I wasn't really sure what it was. Like, should the doctor have been checking? There wasn't any kind of legal precedent for me to be like, oh, the doctor should have checked and not checking was a breach of duty. So if it doesn't give you that in the case, what I would have maybe liked to see as an approach, it came out on the very last cross, something like that the doctor saw the intern swaying. To me, I was like, that's insane. Like at least this doctor had the duty of at least seeing that and at least checking, at least asking if this person was okay, if they were all right, if they had been drinking, if they hadn't been sleeping enough. I think that moment, not checking, was the breach of duty, and that could have been amplified. Maybe like with the first cross of like you were swaying, you were drinking, you were hungover, and this doctor never asked you about that. Something like that to weave it in. I think for D, there was what I was missing is like, okay, but why didn't the doctor just ask to ask? Why didn't they double check? Why didn't they do maybe like go the extra step? And I think you guys could have been like, he did, because you have to think about it like this patient was their own family. There's no way this guy was going to do anything if he did not think his own uncle was going to be safe. Like that's how we can all be assured that this doctor did everything that they thought was correct and everything that they thought would be safe because this was their own family member that they were treating. Could have been a cool approach. It might have not worked with the case, but that's kind of everything that I've got. Anyways, congrats to everyone. I know this is like the final round, so we're getting to see the best of the best, and you guys do show that. So good job to everyone.
All right. Avishi.
Just wanted to say, such a great round. I only have one overarching comment, and this is really just for witnesses and dealing with witnesses, just remembering that these people are real people, and a lot of their mannerisms and the way that they're going to act on the stand, and the fact that they understand that you're in a courtroom. People will also know like the reason why they're coming in. Like the defendant's going to know that what kind of arguments are going to come against them. A lot of times, as the defendant, you've prepared a lot of the things that you're going to say, so it's like the emotion doesn't really kick in until the end. What kind of fun bits do these people have? So just really exploring who these people are as people rather than just like the script you developed will really help it feel more natural. And even then with like attorneys, if you have a fun witness, have fun, show some personality. So just sort of understanding that dynamic, but otherwise really great.
Thank you. Ellen?
Yeah, I wanted to second what Lydia said about clarifying the duty of care because I think both sides brought up the case laws during pre-trial, and it would be nice to kind of read that in and explain that we're like not viewing from hindsight, but what's reasonably available to the doctor at the time. I think it would have like helped clarify a lot of points during the trial. And also, I thought on witnesses, just because you have an expert witness doesn't mean the direct has to be dull. You could add sort of like creative points and add analogies and jokes. And I think a bit of that energy was like missing in the first half of the round, but I think everyone had excellent energy for the remainder of it. So great job, everyone.
Thank you, Ellen. And finally, just for very brief comments from me, one pro and one con. The pro is I really enjoyed everyone's mastery of the rules of evidence. I think at a high school level, this is like amazing. You guys were giving rule numbers left and right. A lot of the higher end objections, 404, 403. When you're objecting, you're using rule numbers. That's amazing. One thing, I think every witness can be less fighty. I think every witness can pick their battles more. Especially with experts, just remember you're not an advocate, right? Especially, I don't think there's much bias. There's no money. I didn't hear a great money pocket. There's not like a huge bias pocket here. You're not here to advocate for your witness. You're here to be very agreeable, fight on the things that truly matter. That's all I have. And I'm gonna pass it over to, as Ian is here, Dr. Ian Lampert.
Hi, everybody. Thank you so much for making this an amazing final round. Do I know it's amazing? I have not watched it myself, but I've seen amazing comments come in for all of the advocates. You're the best of the best of these 38 teams, and I'm so excited to give you first the MVPs and then the overall winner. So we're going to begin with witness MVPs. This was a split decision. 2 witnesses received 1 vote, and then 1 witness received 2 votes. It's the final round, so we acknowledge everybody. So honorable mention receiving 1 vote as the MVP, Mr. Samuel Perez. Congratulations. Another MVP vote goes to Kayla Hua. But your overall MVP in finals, receiving the last 2 votes, Miss Vivian May. This takes us to the MVP attorney. This was not a split decision. Sweeping all 4 ballots, your unanimous MVP, Miss Anya Luo. Now the results. I've now seen several final rounds of IMT. I'm excited to watch this round back because this is the closest I think it has ever been in a final round. The largest margin on any ballot was 3 points. So, in a very close round, it is 1 tie and then 3 votes for one side. Congrats to both teams, but your champions are the defense. Congrats to all. Very, very well done. It's quite late, I know, for at least one of these teams. So if you want to stay on, you're free to. If you want to discuss anything with judges, or if you want to sleep, totally fine. This recording is going to be available for you to watch back in a short amount of time. And I'm going to put all of the comments in the chat now so that you can see, review, and grow. If you're watching this trial sometime in the future and you want to join IMT, 100% free, 100% accessible. We hope that all 8th to 12th graders from across the country and the world join us then. Thank you so much.